Welcome to today's webinar, Supervision and Outcomes Focused Enforcement in Practice. Our webinar today will run for approximately 60 minutes. The first half will feature a presentation from members of SRA staff who will introduce themselves to you shortly. In our Q&A session, we'll open the floor to questions and comments from you. I'll now hand you over directly to today's SRA presenters, Carol Westrop and first Helen Venn.
Good afternoon all, and welcome to our lunchtime webinar on supervision and enforcement in an outcomes-focused regulatory environment. Thank you for joining us this afternoon. I'm Helen Venn, and I am one of the managers in the supervision function of the SRA. I am here today with Carol Westrop, who is Head of Legal Policy. Let me begin by outlining the webinar format. I will start by talking about the SRA's supervision function and the pilots that have been and continue to run. Carol will then go on to talk about enforcement. There will be time at the end of our presentations for us to take questions, and also at the end of the webinar we will provide the CPD code which you will need to claim CPD hours. The slides from today's webinar will be available on our website. So to begin, as I said, I will be talking about the new supervision function within the SRA. Before I talk about relationship management, I just wanted to say something about risk, because this is central to our supervisory approach and how we use our resources. The SRA will assess risk in firms using information from a wide range of sources. The risk of the firm will be used to guide our supervisory approach to that firm. Key issues for us will be the consideration of the risk posed using our resources based on the greatest risks and those which can be mitigated by our supervisory approaches. Our resources are limited and we need to use them wisely and for the greatest benefit. Supervision have been working with the Risk Centre to identify the impact rating of firms on our regulatory objectives, and we will continue to work closely with the Risk Centre because it is the impact rating of a firm which will drive our supervisory approach. So the assessment of impact or risk is about the approach we take to the supervision of the firm. It is not a measure of the quality of a firm, and that's a very important thing to remember as we progress through the webinar. So for high-impact firms, and turning to the slide now, we consider that the approach of relationship management is most suitable. An important point to stress is that high impact does not mean that we think a firm is being run in a risky way. Rather, if that high-impact firm has problems, it is likely to have a high impact on our regulatory objectives. So firms assessed as high impact will be relationship managed. And by this, we mean that they will have a named point of contact at the SRA, a relationship manager. We've been piloting relationship management as a supervisory approach over the last year. You may have seen information on our website about it, or perhaps heard one of our previous webinars. Maybe you've even been one of the firms involved in the pilot. The pilot began last autumn and formally finished at the end of July. Firms were asked to volunteer for the pilot, and we undertook an extensive engagement campaign this time last year to raise awareness of the pilot and to ensure that we had a good cross-section of firms to work with. For the pilot, we did not limit ourselves to firms likely to be high impact because we wanted to have a completely open mind as to how this type of approach could work across all types of firms. I'm happy to say that we had a very positive response, and well over 60 firms were happy to volunteer to take part in the pilot. We were limited as to how many firms we could take, so we took 19, and that was in 3 tranches. And those firms included global, national, small niche firms and sole practitioners, so we had a good cross-section of firms to work with. We made a series of visits to this range of firms, and the purpose of the visits was to test the effectiveness and the proportionality of relationship management as a supervisory approach. Constructive engagement was key, and our aim was to get a better understanding of the risks firms faced and how the firms were run, and that enabled us to put risks and issues in context. Also, we looked at how firms were identifying and tackling their own risks, and we saw a range of models and methods as to how firms did this. We met with a variety of staff from the pilot firms and covered a wide range of issues. We've learned an incredible amount through this process, and we've had some very positive feedback from the firms involved in the pilot. And what have we found? Well, as I said, the feedback to the pilot has been very positive, and we are reviewing what we've learned over the past year, and this will shape how we think relationship management would be used as a supervisory approach. We will be putting forward a summary of our findings on the SRA website. However, we thought it would be useful today to share some of the findings from the pilot in advance. So some key points are that relationship managers have gained, and they need to have, a strong understanding of the sector they regulate and the best practice within that sector. And this can add value to the regulatory process. A detailed understanding of the sector helps us, the regulator, understand and identify risk. Further, that relationship management helps build up a two-way relationship, with firms proactively coming to us with issues. This has happened in the pilot, and where firms have done this, we have worked with the firms through those issues. And both we, the regulator, and the firm have found that incredibly helpful. It has also enabled us to work with other units of the SRA to provide what might be termed a one SRA approach, which again firms have found constructive and helpful to the process. And by a one SRA approach, let me give you an example. If a firm reports a serious financial issue to the relationship manager, which perhaps requires a response from different areas of the SRA, the relationship manager would be able to coordinate the approach and work with the firm to address the specific issue and also any wider risk issues within the firm. So again, that's a central point of contact for the firm. Relationship management can help to elevate risk and compliance issues on a firm's agenda. We've actually had many instances where our engagement with the firm has enabled that firm to look at their risk in a different way. Our view is that large, global and city firms would benefit from the relationship management approach. And we intend to roll out relationship management starting from October this year to those firms we assess as high impact. Firms within that group will be contacted with details of their named relationship manager as we begin to implement this approach. We need to build our resources in this area, as with the rest of the supervision function. And to this end, we will be contacting firms on an incremental basis as our ability to resource this approach increases. So that's high impact firms and relationship management. Now moving on to medium and low impact firms. In exploring the supervision of firms assessed as medium or low impact, we've also piloted new supervisory approaches. That pilot, which we've called the Supervision pilot, started in January. And in January, internal recruitment of supervisors began. The pilot is due to finish at the end of this month. In the Supervision pilot, there are in excess of 100 firms, and as I said, the focus is on medium and low impact firms. And of those 100 firms, there's roughly a 50-50 split between the medium and low impact. Again, the emphasis is on constructive engagement. And so if risks are identified within a firm that we think should be addressed, our first action has been to phone the firm, to talk to the firm about supervision, the approach, risks identified, and to discuss any proposed action. We may continue engaging with the firm by telephone, possibly correspondence. It may be appropriate to visit. In this way, we have worked with firms to understand their business. We've put issues in context and worked through those issues or risks. It's important to note that many matters we've been able to resolve with dialogue between us and the firm. There have been some matters that have proceeded to investigation, and that's where we think the issues are such that regulatory action is necessary. So, the pilot has looked at events that occur in firms and how firms can and should respond to such issues. So, let me give you an example. We receive a complaint about a conflict of interest. We engage with the firm about this. Again, there'll be the initial telephone contact. And during that dialogue, we'll be looking at the substance of the complaint, but we'll also be engaging with the firm about their systems. How do they spot conflict? How do they deal with conflict? What checks are they currently carrying out? How do they undertake the checks? Perhaps how regularly are they undertaking conflict checks? So the emphasis is not just on dealing with the current issue or event that has occurred, but it's aiming to ensure that systems and processes prevent any such issue occurring again. So in addition to looking at events within firms, the pilot has also looked at thematic work. For example, there's been a thematic piece of work around first-tier complaints handling. Here, we have carried out visits to a random sample of firms, and we've been looking to test matters such as what do firms consider a complaint to be? Because there's a very wide range of answers to that question. What does good practice look like? Feedback from the firms in the pilot has been extremely positive. In particular, firms have commented upon the fact that that first contact by telephone is very much appreciated. They've also fed back that the engagement has been very constructive. As I mentioned earlier, we are currently recruiting, both internally and externally, to fill these key roles in the business, that key roles of relationship management and supervisors. So we're looking to build out resource, and we'll roll out the supervisory approach of constructive engagement across all medium and low impact firms. We aim to be in a position in early 2012, so early next year, we aim to be in a position where every firm will be assigned to a supervisory team at the SRA. We will keep you updated of our progress toward that goal via the website and webinars such as these. That said, let's look at a case study so I can talk you through a further example. And perhaps staying with the theme of conflict of interest, let's say we receive information about a conflict of interest. This has occurred at a firm we assess as medium impact. We assess the event, so the conflict event, we assess as medium risk. That assessment is then considered by the supervisory team responsible for that firm. A supervisor within the team explores the risk profile of the firm, and it's noted that 3 out of the 4 categories in the data profile, so that's 3 out of the 4 categories of the firm's risk profile, are green. However, the firm's operational risk has been assessed as amber. The supervisor also notes that a previous engagement with the firm has taken place, and during that engagement, weaknesses were identified in the implementation of processes with the firm. Again, the supervisor contacts the firm initially by telephone, and discuss the issues. The firm agreed to review the conflict procedures and at a later date agreed again between the firm and the supervisor to provide information to the supervisor that they have done so. This engagement will then continue until the supervisor is satisfied that the issues have been addressed. If appropriate, the supervisor may visit the firm to discuss systems generally and also review what the firm has done, particularly in relation to the conflict process. So this is just one example of how supervision may work in practice. Before I hand over to Carol to talk about enforcement, can I encourage you all to look at our website, which contains information about both pilots. That's the relationship management pilot and the supervision pilot. Further, there are previous and forthcoming webinars that you can listen to, which again provide more information about our supervisory approaches. I'll actually be here next week on Wednesday the 14th of September, delivering with a colleague a webinar covering the topics of risk and supervision. As I discussed at the beginning of my presentation, the two functions are inextricably linked, so that's a good webinar to tune into if you need some more information, and I hope you'll join us for that. Again, it'll be a 12:30 start. So now I'll stop plugging our webinars and our website, and I'll hand over to Carol to talk about enforcement. Thank you, Carol.
Thank you, Helen. Those of you who have looked at our website previously, or perhaps been to our roadshows or our webinars, will have heard about our new approach to authorisation, supervision and enforcement. Well, Helen's talked to you about our new approach to supervision, and I'm going to talk to you briefly about our new approach to enforcement. What do I mean by enforcement? Well, first of all, let me reassure you that what we mean by enforcement in the OFR regime is not light touch enforcement. I've done a number of roadshows over the last 15 months or so, and generally the attitude of the profession is to welcome and indeed to encourage a robust and strong enforcement approach to those firms or individuals we regulate who deliberately breach the high ethical standards that both we and you hold so important. So the aim of our enforcement strategy is to be effective, proportionate and fair, using our limited resources in the most effective way to target the areas of highest risk. We will aim to be transparent, and in our website and our publications we have published our decision-making criteria, which sets out how we approach reaching decisions in relation to our enforcement work, and those are on our website should anyone wish to look at them in detail. Enforcement work is overseen by the Legal Directorate, and the decisions we make are fully accountable both internally through a range of appeals and externally to both the High Court and to the Solicitors Disciplinary Tribunal, which has been nominated by both us and the Legal Services Board as the body to hear appeals from decisions that we make in relation to the exercise of our disciplinary and regulatory powers. Overall, we are seeking to achieve, insofar as possible, consistency of approach in relation to both traditional law firms and alternative business structures, which we are hoping to license at the early stage of 2012. So turning on to how we will enforce, in 2009 and 2010, we consulted on our enforcement strategy, and we received in general a lot of positive feedback in relation to the approach that we intended to take. Now, the enforcement strategy, which is published on our web, sets out the framework of when and how we will enforce, as well as setting out the outcomes that we seek to achieve by our enforcement action. And these are fourfold. First of all, the encourage of compliance with core principles and other regulatory requirements. Secondly, the credible deterrence of behaviours that breach the core principles. Thirdly, the control of firms and individuals that represent a risk to the public or the core principles. And fourthly, removal of those who represent the most serious risk to the public and to our regulatory objectives. Now, as you know, outcomes-focused regulation is about empowering firms to adopt their own systems and exercise their own judgment, so they can deliver a good service to their clients in a way that best suits their business. But for this reason, our enforcement strategy places a very important emphasis on engagement. The aim, wherever possible, is to help firms to comply. Where things go wrong, we want to work constructively with firms to reach an agreed solution that protects the public interest. This is essentially what is new about our enforcement strategy. However, we are very clear that where firms or individuals fail to cooperate with us, or significant risks are posed, tough enforcement action will follow. We will operate a risk-based approach to enforcement, and a very important part of the analysis is an understanding of the risk which the approach is intending to remove, or more often to mitigate. So the outcome of our informal enforcement action will be proportionate to the risk posed. At heart, our enforcement strategy has a risk-based protection of the public interest and the importance of credible deterrence at its heart. So what enforcement tools do we have? Well, we have a range that we can employ depending on the type of investigation or the type of action that we wish to deploy. We have strong statutory powers in the Solicitors Act and the Legal Services Act, as well as other subsidiary legislation for both traditional law firms and ABSs to obtain documents and information from both regulated persons and third parties. When necessary, we will enforce through the High Court when necessary. We can impose conditions on practicing certificates, on an ownership interest of an alternative business structure, and on an entity's authorization, both on its recognition as a recognized body and on its license as an ABS. So through the imposition of conditions, we have the power to limit or circumscribe the activities of regulated persons if it's in the public interest for us to do so. The purpose of the conditions is set out clearly in our rules, which form part of the handbook on the web. Increasingly, we have moved towards, in our enforcement work, looking to see whether a referral to the Solicitor Disciplinary Tribunal is the best outcome in the public interest. And we have, since 2007, used regulatory settlement agreements as a way of seeing whether we can reach an agreed outcome with a firm under investigation. RSAs, as we call them for short, set out our view, agreed with the firm under investigation, of what the right outcome should be. This normally requires a firm to accept that they may have acted in breach of the rules, but have taken steps to make sure that such actions do not reoccur, and to put right where things have gone wrong, where possible, by, for example, correcting misleading client information or repaying monies wrongly charged. We have so far entered into about 90 such agreements, the vast majority of which have been published on our website, and it is intended that both in supervision and in enforcement work that they will form an important plank of our work going forward. If we can't reach an agreement, or if formal enforcement or disciplinary sanctions are required, we have a range of disciplinary sanctions to protect the public by removing serious risks. Many of you will have read of strike-offs that have been made by the Solicitor Disciplinary Tribunal of solicitors, some of which are reported in the Gazette, and many of you will have seen the SCT's findings which we publish. Every year we apply to the tribunal to strike off about 300 or so solicitors in the most serious of cases, normally where there's been dishonesty, serious risk to client monies, or some other very serious misconduct. In addition, the tribunal has the power to suspend a solicitor or those we regulate from practice, and we will have similar powers in relation to managers, employees and role holders of ABSs to disqualify them from holding positions within ABSs. The action we seek to take by strike-offs, suspensions and disqualification is to ensure that the risk of that person doing the same misconduct in the future is removed, but also to deter similar behaviour from others in the future. We've also got, and have had since June 2010, an internal power to issue fines up to £2,000, and we can issue rebukes, again, which can be published on our website. In the most serious of cases, we have powers of intervention. Every year we intervene into approximately 60 or 70 firms where the grounds which are required under the Solicitors Act or the Legal Services Act are made out. For example, we have reason to suspect dishonesty, we've got breaches of the accounts rules, or in some cases where practitioners got into difficulty because of abandonment, bankruptcy or ill health. In relation to the latter category, we would urge that for any practitioners who are in difficulty with their practice, that they should contact us to discuss alternatives to intervention. Clearly it's a very draconian power that causes a great deal of disruption to both clients and can be very expensive. So we want to work where possible with firms to encourage an orderly wind down or close down of a firm if there are difficulties in practice. The aim of our enforcement tools and our action is to be consistent with both traditional law firms and ABSs insofar as possible and as allowed by the legislation. So turning now to enforcement in practice, some of you may be concerned about enforcement against the core principles, which hopefully you've read about, and a concern that we might be looking to retrospectively assess people's compliance. The importance of supervision in constructively engaging with firms to put things right or to understand a firm's position is vital to the process. But where enforcement action is required, we would reassure you that we have actually successfully operated aspects of outcomes-focused regulation for many years. For example, applications before the tribunal generally rely on high-level principles such as those in Rule 1. We normally would allege a failure to act in a client's best interests or failing to act with independence. Where more prescriptive rules are required, for example in the Solicitors' Accounts rules or the indemnity insurance rules, those rules, as you know, continue virtually unchanged. And when necessary, we will enforce against those rules as well. But for most of our disciplinary work, we are looking at enforcing against the core principles, and that will remain unchanged. We have, as part of our enforcement work over the years, been used to dealing with informal dialogue, discussions and negotiation to try to agree a position, to agree a statement of facts or admissions in our disciplinary work. And I've referred previously to the importance of regulatory settlement agreements and trying to negotiate a position and agree a position where we think we can reach an outcome that best serves the public interest. So we think that achieving OFR in enforcement work is perhaps not as complicated or as novel as some might think or as perhaps some might fear. But what is clear is that a key aspect of outcomes-focused regulation and our enforcement work is that it is not necessary to take formal action for every breach of a principle or failure to achieve an outcome. You heard about our new approach to supervision from Helen and the development of our risk structure. And the important point is that staff will be empowered to take decisions about necessary and proportionate action in the public interest, including when it's not necessary to take action as well as when it is. And I would just stress that cooperation with the regulator is key, both in terms of supervision and enforcement work. I would urge those of you who are perhaps subject to investigation to engage with us fully, even if enforcement work proves necessary. Do not simply hope that matters will go away, as they generally will not. You will know that one of the new core 10 principles requires you to cooperate with us as your regulator and with other regulators such as the legal ombudsman. Consider if you can put things right. Have things gone wrong? Have you learned any lessons from the investigation or the action we're taking? Can you put anything in place to stop it happening again? If you can, then we want to work with you to ensure that you can reach a state of compliance without the need for formal enforcement action. But if it's such that we are taking matters forward, consider taking legal advice if you think you need it. The Solicitor's Assistance Scheme can help to provide advice from an expert panel of regulatory lawyers. And our website also provides a lot of information about our investigatory and enforcement processes. If you're in financial or other difficulties, the Law Society certainly can help, and there are a number of organisations such as Soulcare who can provide advice, information and assistance. All of these are set out in our website, and again I would urge you to have a look at them. So overall, what I want to try to stress is that we are looking to achieve an effective balance between constructive engagement in our enforcement work, led by supervision, but also by those of us in the Legal Directorate, but also that we will take strong enforcement action where we think there are serious risks to the public, a breach of the core principles, or risk to our regulatory objectives. Now, I think at this stage we have a polling question, which we would be very interested in receiving your feedback on in the light of what perhaps I've said today or what you've read on our website or more generally, is whether you think that the SRA has got the balance right between constructive engagement and strong enforcement action where serious issues arise. And you've got three options on this: agree, disagree, wait or see, or I think it says no vote. And we are actually, in a very clever piece of technology, able to see the votes as they come in. And actually it looks as if the majority of you are waiting to see, which we find in some ways completely understandable, because we are devising our processes, and really I suspect a lot of you will think that the devil is in the detail and you want to see how it works in practice.
Yeah, I think it's encouraging to see at that stage that there are no disagreements, and again I'll stress that within the pilots we've been running in supervision, that balance is being positively received, and there's been lots of positive feedback. Perhaps there's 2.29% who currently disagree with the balance between constructive engagement and strong enforcement action. We would urge, at the risk of mentioning the website yet again, there is a contact mechanism, an email address there, and we would really urge listeners to email in any particular comments or feedback they have. So perhaps those people that don't think we've got the balance right, please tell us why you think that's the case, what we could be doing differently. Likewise, anyone who thinks we have got the balance right, please also, we would like that feedback. And as I say, there's a mechanism, a contact email address via the website. So thank you all for participating in that polling vote.
Thank you, Helen. Well, I'm just going to now turn finally to two case studies that I've prepared, based on real life, but now anonymised and fictionalised examples of some enforcement work that I've recently been involved with, to show you how we think it actually will work in practice, and perhaps to exemplify one element of what we hope is our new approach. So in case study one, there was a large regional firm, and the compliance officer for finance and administration finds out about unexplained withdrawals by a senior solicitor who generally deals with probate matters. Now, as we would normally expect in this kind of situation, the firm's management, perhaps a senior partner, will order an investigation. And as often happens, the solicitor has been suspended by the firm pending those investigations, and we are told about the potential misconduct. We will obviously assess that as a high-risk event because it looks as if client monies have been taken without due authority, and we would normally seek to investigate that quite quickly by supervision. So we investigate and we show serious misconduct by the solicitor. In effect, what she's been doing is creating dummy bills on probate matters, normally where the charities are beneficiaries, so there's no beneficiaries normally to chase up the progress of the administration of the estate, to disguise personal transfers to her personal account. So the firm, in conjunction with the supervision, agrees to check files and make good any losses to clients. But what supervision also find out in the firm is that there are a number of weaknesses in the firm systems. For example, there are no file audits, no control on withdrawals from client accounts, and the firm readily accepts that there are weaknesses in its processes and lessons that could be learned to make sure that that risk isn't posed in future. So the SRA and the COLP will work together to agree a compliance plan to ensure that those issues are addressed. And that would be reviewed and monitored by us as we felt appropriate in conjunction with the firm. No enforcement action is necessary about the firms or its managers because we've addressed the risk that that action has posed. However, the solicitor has been referred to the Solicitor's Disciplinary Tribunal, which has the power to strike off or suspend the solicitor from the role. In the meantime, enforcement works and puts a condition on her practicing certificate to ensure that she can only work in employment which has been approved by us, again, to control the risk that her actions have caused to the public interest. At the hearing before the tribunal, the SCT have found her dishonest. She advances mitigation that actually she was taking the money to help prop up her husband's business and intended to put it back. But the SCT, applying the test that they applied to these circumstances, find out that she knew what she was doing was dishonest and that the ordinary standards of ordinary people would find her actions dishonest as well, and so they strike her from the role. In terms of our existing enforcement work, we are used to taking such cases to the tribunal, but what is slightly new is the emphasis on constructive engagement with the firm and the managers in relation to drawing the line on enforcement action against others involved where it's not necessary and the risks have been addressed. The second case study is in relation to a sole practitioner in the High Street dealing with perhaps mainly conveyancing work who has practiced with an unblemished record for many years but now suffers from ill health and is the main carer for his disabled wife. We receive in the SRA intelligence that client calls are not being received or returned and that the office appears to be closed. Again, this will be regarded, once we have done some preliminary investigatory work, such as just checking to make sure that that is indeed correct, again as a high-risk potentially event, and the firm is visited. The supervisor would work with that individual to try to work out what we can do to close down the firm in an orderly manner, since he confirms he no longer wishes to continue in practice, bearing in mind the demands on his time and his ill health. And that would be often put into a plan regarded in terms of daily monitoring until we were sure that the matter had been resolved satisfactorily. However, in my fictional example, the practitioner is suddenly admitted to hospital. We are informed by his son that the matter has now progressed in that way and that there is no one else who is able to take over the firm or the running of the business. We receive a telephone call from a client who says that she's due to complete on her conveyance the following day and is very concerned to know what's going to happen to her house move. So we refer the matter to enforcement and we obtain, in the circumstances, an urgent resolution to intervene into the practice to protect the public interest on the grounds of that person's ill health. We appoint intervention agents to collect the files, and the practice monies and clients' monies vest in the SRA as statutory trustee. An emergency grant is given by the compensation fund to allow the imminent completion to conclude, and we would endeavour to keep the sole practitioner and his family informed of the action we're taking. In this fictional example, the intervention agents report that the accounts of the firm have been reconciled and there was no other issues of concern in relation to compliance with our rules and regulations, and client account is intact. The intervention will then conclude, and we would take a proportionate view about what enforcement action is required in relation to that individual. In this example, we decide that we don't need to take any further action and he retires from practice. So those are just two examples by which we hope to perhaps illustrate how supervision, to a certain extent risk, and enforcement will work in practice. Now I think we have another polling question, which I think we're just waiting to come up onto the screen before we actually move into the question and answer session of the webinar. So the question is, has this webinar improved your understanding of the SRA's supervision and enforcement action? A lot? Somewhat, but you might like some more information. That it hasn't improved, or that it has no vote?
Again, we've got the votes coming in. The vast majority, over 70%, feel that there's an improvement but would like more information. Yet again, I'm going to plug our website. There's lots and lots of useful information there. In particular, there's a publication called OFR at a Glance, which is a really good starting point. It has all of the basic information and lots of practical guidance. There's a very small number who feel this webinar hasn't improved their understanding. Those people, again, as we said during the last polling question, please do email us in. Let us know why it hasn't helped and what you think could be done to improve your understanding of the supervision and enforcement activities. And we're very grateful to see that over 20% feel that this webinar has improved their understanding a lot.
Yes, thank you, Helen. I mean, I would just echo Helen's reference to OFR at a Glance. It's, I think, on a prominent page on our website. I found it most useful, and other practitioners that I know have also found it very useful, and I think it's a very good starting point and an overview for you and others in your firm to see in a readily digestible format what OFR means practically for you and your firm, and how authorisation, supervision, risk and enforcement will hopefully come together in the OFR world to ensure that we deliver what we hope that we will be able to deliver in the future. So I think we're going to turn now to any questions that anyone has.
We are. In fact, we've had some questions in as the webinar's been progressing, and they all relate to risk. There's one question which I'll answer initially, and then the other questions we've received relate to general areas, so I'll group them together and answer them. But somebody has asked for confirmation of the 4 risk categories used for risk assessment. Those are the 4 risk categories I referred to in the supervision part of this webinar in the case study. And those 4 general categories that will be assessed are fraud and dishonesty, financial difficulties and instability, thirdly operational risks, and fourthly competence, fitness and propriety. And in the case study that I gave in the supervision section, it was the operational risks that were being flagged as amber and caused the constructive engagement to commence. I think the other questions on risk, I'll read out a couple of them and then I'll answer them in the round, if I may, Carol. Yeah. So there's a which department do we contact to request disclosure of risk assessment? Does a firm wait to be informed? by the SRA as to whether they are high, medium or low impact? Are we given risk score ratings? And there are various questions around those areas. And I'll just start, if I may, before addressing them directly, to remind people that we have always said as the regulator that outcomes-focused regulation shouldn't cause any concern for well-run firms. It seems, and Carol and I have both been doing roadshows and webinars for several months, and it seems that the more the profession learns about outcomes-focused regulation, the more reassured they feel about the changes it will bring. We did conduct a survey recently that showed 2/3 of respondents who are familiar with the principles of OFR did not think it would mean a radical change in the way they conduct their business. So please, this is a positive change, and it shouldn't have any detrimental effect if you're a well-run business. So that's general background. But just in relation to risk, if I could just again remind people that there is a webinar on Wednesday the 14th of September which covers risk. Secondly, flag up the comprehensive section on the website in relation to the risk centre and risk assessment and so on. And if I outline how we will be assessing risk, there are two elements: the impact of significant failure and the probability of that failure occurring. And again, just a reminder that its impact upon our regulatory objectives. So as a regulator, we've got limited resources. We cannot actively supervise every firm in the same way. And so, as I mentioned, we'll be allocating an approach to supervision based on the potential impact a firm may have on our regulatory objectives.
Thank you, Helen. The live questions are now coming in as well, thick and fast. So first of all, I'm just going to deal with a question that we've received, which is, have your disciplinary powers against non-solicitors, employees of a traditional law firm been extended beyond Section 43 of the Solicitors Act? For those of you, I'm sure you do know, but Section 43 is the power in the Solicitors Act which gives us the power to require a non-solicitor employee of a firm to require approval from us before they work in a firm regulated by the SRA. The answer to the question is yes, they have. Our disciplinary powers were extended in the changes to the Solicitors Act by the Legal Services Act and reflected in our current SRA Disciplinary Procedure Rules 2009. So for employees, we can also rebuke them and fine them up to £2,000 if they breach our rules. So in addition to the Section 43, we can now take direct action against an employee in a traditional law firm if the factors set out in those rules in favour of disciplinary action. For example, we have to show that the behaviour wasn't inadvertent or trivial, and that it actually was deliberate or reckless and seriously affect the public interest, then we can take disciplinary action in relation to them as well.
Thank you, Carol. We're getting lots more questions in about risk, quite understandable. People asking about knowing about their risk rating. The measures in relation to assessing risk are the size of the firm, the potential vulnerability of its clients and the amount of client money it holds. And on that basis, because the size of the firm is determinative, it's those larger firms that are likely to be high impact. I can say that the vast majority of firms will be low impact firms. And at present, there are no plans to tell firms what their risk score is or their risk rating, but that's because, of course, it will fluctuate. And in isolation, it won't tell a firm anything at all. In relation to whether the firm is assessed as high risk, I outlined that over the coming months, starting from October, those high impact firms will be advised on an incremental basis who their relationship manager is. In relation to the legal community, that's going to be a very small percentage. Medium and low impact firms, again, will roll out the approach from October, but there won't be necessarily a communication as to your risk rating, again, because that can change. But you'll be aware of your impact rating in relation to the type of supervision you experience. So if you're not advised that you have a relationship manager, then you're medium or low impact, and I've already outlined those measures.
Helen, there's a good question that's just come in from a listener, if that's the right phrase. Is there a self-assessment risk questionnaire? Which I think is a very good point as to what we will be doing in terms of helping firms to risk assess their own processes and procedures to make sure they're compliant. And I think, I'm not sure I know the answer to this. I think the intention is that we will be doing much more online to make sure that we have the ability to firms to look at self-assessment tools, but I will take that question, that thought, back to the risk development team for them to consider.
Yeah, we will take that away, and as I say, we can actually perhaps bring the answer to that question to the webinar next week. As I'll be here with Andrew Garbutt, the Director of the Risk Centre, we'll answer that question next week.
It's a good idea, Helen. I've got a question from Sarah in relation, I think, to the first case study that I talked about, which is a question which has been echoed in roadshows I've attended, is would we be intending to discipline the firm or one of the compliance officers, i.e. as well as the case against the solicitor, disciplining either by way of RSA, that's a settlement agreement, or referral to the STT. I think there are just two things to say about that briefly. One is that no, we wouldn't, because the firm, through their action, would have mitigated and put right the issues that we talked about, which is where we had deficient systems and unauthorised withdrawals from client account, because the firm had constructively engaged with us to put matters right and to make sure that the actions didn't happen again. So in those circumstances, absent any other factors, I don't think that any disciplinary action would be required. The second aspect of that is the COLP, the Compliance Officer for Legal Practice, in the frame? And the answer is quite clear. No, the COLP and the COFA are there because they are people to whom we will have a relationship with, and they have responsibilities to ensure reasonable efforts to comply with the rules. But the responsibility for compliance with the core principles and the rules rests with the firm and its managers, and not with those individuals.
Thank you, Carol. A question asking whether well-run firms can also benefit from the SRA's intelligence on emerging risk. The short answer is absolutely they can. And again, the website will be holding information about emerging risks. There's already, for example, for consumers, there's a section on the website about current issues, or if there's a particular fraud, then that can be publicised on the website. And the intention certainly is to have that information on emerging risk on the website. As I say, please do look at the comprehensive risk section, and then as we implement in October and develop and have an approach to risk supervision and enforcement, then more and more information and current information will appear on the website. And as we engage and gather best practice, we're also looking at the most effective ways to share that best practice.
Okay, we've got time for one more question. I'll just deal with a question from Mohammed, which is quite an interesting question about the type of conditions on practice certificates, ownerships and authorisations might we wish to impose. The short answer to that is that the conditions have to be tailored to the risk posed. The High Court is very clear in relation to our enforcement work that that's the case, and therefore it's not really easy to give a clear answer as to what kind of condition might be imposed, because it very much depends on the factual circumstances and the risk posed. But if you look at our authorisation rules and the practice certificate rules, they set out clearly the test that we have to imply in our work as to what we are hoping to achieve by the imposition of the condition, and it's normally to mitigate the risk that that action imposes, or to stop them from being involved in a particular area of work, or, for example, to take remedial action, attendance on a course, more frequent submission of accounts, depending on what we identify as the concerns that their action has engendered.
Thank you very much. We can't take any more questions. We are seeing your very useful feedback already, which we're grateful for, as we are for the questions and the interest.
So that just reminds us to say thank you very much for dialing in. We are very grateful to you for taking the time and for the comments that you've made and the questions you've raised, which we will take away with us and consider very carefully. And if it looks as if we need any further certainly input from me on the enforcement angle in terms of webinars, then we will endeavour to put that in train.